ESCA. I think what's very interesting to see there is obviously in the DFSA rules it makes it very clear that funds being passported through this regime will be able to be marketed and then including other activities such as advise and arrange within the DIFC. But funds that then go through this passporting regime, the text of the ESCA regulation will be key to understand what can be done within ESCA regulated territory. One can assume, for example, promotion under the promoting and introducing regulations, promotion. But a big question mark is, in ESCA regulated territory, will it also cover advising? So investment advice is a separate regulation. It's regulation 48R of 2008.
Yeah, it goes a long way back.
Yeah, so
it's a 2008 regulation.
It's a different ratio. It would be very
Correct.
interesting to see that, because I have yet to see either an ESCA bespoke regulation or B, an amendment to the promoting and introducing regulations.
This is an interesting question. You're obviously not the first person. Mr. Harron here has made the same observation. On the 11th of March, all three regulators came out and made the joint statement. Okay, and it was stated it is now available. But we were obviously trying to make sure that, as you can imagine, the regime doesn't really work if the rules are not published by all three regulators. So although you cannot, and I don't know if you've ever tried to navigate the ESCA website, it's not always the easiest to find those regulations, but we are being told they have been issued. So that's the first point. On your second point as to what...
They weren't issued as of Thursday.
Yeah, we all checked. We all checked, but we are being told...
I couldn't find them either.
And we have to go back to the 11 March public statement now to come back to your question, which is, you know, are we sure that their regulations would say the same? And on this particular point, marketing promotion, which they have never saw to also include advisory. Okay, we all know that. All that I can tell you is that the protocol in itself has, and I have it here, it's a very confidential document, not to be shared with anyone, but I have it here. At the end of the protocol, there's an agreed set of rules. Okay? And that agreed set of rules was pretty much drafted by the DFSA, I can tell you that much. So that's why, even if you look at the DFSA and the FSRA rules, they're pretty much the same. And obviously each regulator have, you know, a slightly different way of, say, defining a fund, for example. And if you go to the protocol rules, the way that it was drafted, we drafted it in such a way to make provision for both regulators. But on this particular point, I can assure you, and you know, not in a public place, but I can assure you that that particular point has been covered in the rules.
Okay, we've got the rules and we've reviewed it, and I can let you know that it's similar to what the DFSA has issued.
Thank you.
I would just add to that as well that obviously legal teams across the organisations have worked extensively over the last 3 years, as Jacques mentioned, to have things implemented. That's been confirmed by all three regulators, and then subsequently at an operational level, at the kind of fund team supervision stage, we've all confirmed that we're ready and live as well. So if that helps.
I mean, there is, and I'm sure a lot of you have noticed this. If we take the situation back 3 years, and maybe how parties would have regulated for certain activities, say 3 years ago, or even less, 2017, you would have had ESCA regulations coming out that to this day never refers to, in its preamble, to even, you know, Law 8 of 2004, the federal law that created, as if it didn't exist. I think you will see that slightly changing now. There is a financial blueprint for the country. People have recognized that there should be the regulatory playing field should be simplified, and additional layers of regulation should be removed. So it's certainly not a situation where ESCA is sitting there waiting to pounce on people that may have misunderstood that.
Yeah, and I think for for this to really take off, It would be, I mean, I don't know how it would really work if all three regulators did not sort of agree to similar requirements and rules surrounding, the passporting or the promotion and marketing of funds.
And that's why it was also a key point that not any single regulator, now that they've agreed to this, what is called in the document a common legislative framework, is not any single one of them can now unilaterally amend anything in relation to this. There is a clause in an all fall down situation where a regulator may decide to step away from the regime, but not a single one can now, ESCA cannot now go off again, just issue further regulations that conflict with us. So that brings the prepared sort of portion of Divya's questions to an end, which means we can go to the more interesting part of the discussion. We can speak to a couple of individuals that are obviously at the coalface, that have funds in play from a DIFC related perspective and operate into mainland UAE. And from that perspective, Mr. Harron,
Thank you.
Thank you for coming.
Pleasure. I suppose I should start with the obligatory pat on the back to DIFC, DFSA, ESCA and ADGM in respect of the protocol. I think Jack mentioned that it was taken over 3 years, so it's probably beat Brexit. There is a kind of parallel there, and we've ended up, if you follow this kind of thing and you're British, with a withdrawal agreement, which is kind of like, okay, but there's some questions and there's a lot of work ahead, and I think that's a parallel with some of the fund protocol that we have. I was being slightly facetious, but it is a good step forward. It is an achievement. I think we tend to forget, because we're so used to this concept of free zones and different regulators, that it's quite a unique situation to be in, and so that is definitely a step in the right direction. I know Jack has some questions, but I do have some general comments I was going to pick up on.
Please go ahead.
And some of the things that were said, and just picking them up generally. I mean, so RCAM has 2 DIFC funds, just to put it in context of our experience. One is a public, both are umbrella funds, one is public and one is an exempt, and both have various sub-funds. Both are currently registered with ESCA. Of the public is obviously for public distribution, and also the exempt for private placement, and there's a distinction under the current regime. So we obviously are interested in anything that makes our life easier, and some of the things that I think I've heard are, again, in relation to one of the attractions is not having to appoint a local promoter. And on the face of it, that's quite attractive, because you think, I don't need to share fees or pay fees or retrocessions or whatever it may be. But I think practically, depending on your model of business and depending on your reach, actually a local promoter is pretty important for you to distribute a fund, because they will generally have the infrastructure, the platform onshore. They typically in the Middle East, in this region, funds on platforms are held via omnibus, so your promoter will be the investor of record, and they back it out. So you do need, in some circumstances, especially for public distribution, and to an extent for exempt fund or private placement, a local promoter or partner onshore, because very few institutions in DIFC have that kind of big reach. Especially, I suppose, Divya, you mentioned specifically retail and reaching all those retail type investors. So there is an advantage, I think, if you have a qualified investor fund and targeting 4 or 5 different types of individuals. Yes, you have this freedom to go straight in, but in other circumstances, I think you need a local promoter. So I think, and if you accept that and you need that, then one of the key perceived advantages of the protocol isn't necessarily there. So, and the other thing I've heard is about efficiency and simplicity. And again, yes, that helps, ideally one-stop shop, but again, coming on particular issues, I think were raised by the gentleman over there, as a practical point, is like fees, and for a public fund is the custodian appointment. The custodian appointment is more important. So for a public fund, there's now a requirement for you to have a custodian who's licensed by ESCA. We do not. Our custodian is in DIFC. And again, it was mentioned, well, when you debated it with ESCA, well, we'll accept a sub-delegation down to another custodian. So we could, if we use the protocol, we go and appoint an onshore custodian, and they sub-delegate it back to DIFC, and then it's fine, okay? That's, business as usual. But I don't think it's necessarily that simple, and it also comes back to issues that have raised about conflicts of laws. We would be in a position where we've appointed onshore one contracts deemed to be under UAE law, back to DIFC under DIFC law. The assets are actually held in DIFC legally. So apart from an extra layer, an extra cost, the uncertainty and legal risk in having that extra layer where I know I can go to a custodian in DIFC and get effectively my assets, I've now got to pursue via a chain of contracts into the UAE back to DIFC. So that's a real issue, and one I've not tested. There are always solutions and ways around this, but I mean, apart from conflicts of laws, there's issues that I haven't looked into in depth, but client asset protection. How do I chase my assets? How do I get my assets? And those are real issues that I think need to be considered. I mean, bear in mind, and I suppose this is the point, currently our public fund registered with the ESCA has no requirement to appoint an onshore ESCA licensed custodian. So it's an anomaly, and that's one that for us is an issue. Why put extra problems or potential difficulties in place? I suppose my next point would be, again, a small point, but a practical one, is the fee cycle. When you actually pay the fees, and I think it was alluded to, is when can we register? So if ESCA has a January to December registration period. So January, I toodle up on the 1st of January and pay my $9,000, which is the same, the fees are roughly the same, give or take a couple of dollars. And that's me done for the year. But if I come up, toodle up in November, wanting to register my ESCA fund, I'm paying for the full year, even though it's only for a month or so. So DFSA, in their credit, have an anniversary date, so you get a full year whenever you register. So that's a good thing. But obviously we've registered, so we wouldn't even be thinking about this, because there's no refunds available, unless you tell me different, until January, because we're just not going to pay twice. So, and I think the third thing, and forgive me if I sound as if I've been bottling these things up and wanting a platform.
It's all yours.
And as you mentioned, and that's the key, is that I looked on Thursday as well for ESCA regs, and I couldn't see anything apart from the announcement. But I'll be very interested to see it, because in terms of legal certainty, the DFSA has enacted ancillary regulation to effectively say anyone we talk about going out, but anyone coming in is not deemed to be advising, arranging, they're exempt from having to register and put a place in here as a fund manager, as long as they've passported in, if you're coming into the centre. So that's the ancillary regulation certainty that ESCA, I haven't seen anything like that. So the concern would be okay, I can promote, but do I have certainty that I'm not in breach of other regulation? Now, and until that happens, it would be difficult, I think, to think about taking that risk. And then you could go to a law firm and say, give me a legal opinion, but I doubt at the moment most law firms would be able to give you a clean legal opinion. I mean, if Tamimi can, we may come and see you. So you've got the rules.
Yeah, I do.
So things of those really practical nature in how it operates are things that are at the forefront of my mind, sitting at RCAM with DIFC funds, and thinking about those issues. And I suppose my last point, coming back to local promoter, is apart from the obvious commercial benefits potentially of having a widespread distribution platform that you can hook into, coming back, I think, to issues that were raised about complaints and issues of litigation and conflicts of laws, obviously a local promoter, when he accepts the fund, has a regulatory and legal responsibility to ESCA. And he's the one actually marketing and promoting in the UAE onshore. So the fund sits behind him, or the fund manager. So again, this is all my personal views, is that what you've created there is a layer of insulation, potentially, if there are problems. And I think we've all seen or heard of quite astounding judgments of UAE courts in relation to investors in funds. And so there might be also a consideration that we want someone in front of us. It's not a question of shirking regulatory responsibilities or legal responsibilities, but it's sometimes good to have a buffer, especially if there's some other added benefits to it in terms of distribution.
A patsy of sorts, a fall guy.
I wouldn't use the fall guy term, but I'm just saying that you don't want to be in a situation where you're tied up, dragged through the Dubai courts for really taking advantage of a regulation that you should be able to take a step back and say, those guys are doing it. So I suppose those are kind of my...
The question is, are you excluding your liability? You may be, they may be taking, and as you rightly pointed out, but the question is, are you really, if you look at some of the undertakings that you've got to file, are you really, can you say confidently that, you've really insulated yourself or you've excluded your liability?
You could never do that.
Even if you did, I don't think a local court will see it the same way.
And I don't think the local courts
or ESCA will see it the same way.
Well, that's the point.
So it's not really, I would say it's yes, it is probably a mitigation factor, but it's not something that you're excluding liability. There is liability for both.
Well, of course, but I suppose, and that's absolutely right. And if you, for want of a colloquial term, done wrong, then fine, you should be held accountable.
Yeah.
But if you have, but the point would be that they'd come and have a go at me in DIFC courts.
Maybe
well,
not.
maybe not. But I've got a good argument to say
Yeah.
I'm in DIFC.
That, as I said, that's an argument, and that's a good argument. But that would again be contingent upon the court. You may, you may be sued in. So I'm not sure whether you really.
It's not 100%, and I don't even want to pretend it is.
Yeah.
But it's definitely, I suppose, any advantage to mitigate a risk that I don't have to run as for the business is something I would consider. Would it be the primary concern? Absolutely not, and I agree with you. So I suppose really those are the kind of things I've been thinking about in my head since the protocol has come out. Again, I don't want to be unduly negative, and I'm not, but I think there are just some practical things, like any regulation.
Yeah, like any
and
other regulation.
especially in a context where three regulators come together, it's always an element of getting a framework, compromise, and then building on it. And since there's a secret codicil to the fund protocol rules that we're not aware of, who knows what could be in the
And it's all in the rules.
Oh, it's all in the rules.
There's nothing in there that's not in the rules, I can tell you that much.